I don't think I can read and hold the phone all at the same time. So I'm trying to set it up. And my phone's about to die, so I want to make sure I get this, because I took the time to write this shit. It said I asked the court to review a prior decision under squiggly 14.69 using scope of judicial review where defendant plaintiff met C, D, E, F in basis of facts under the law squiggly UBD.3. squiggly subdivision 2. And I used the case with Paul Berchi, I believe, case number 27 VB 137188. Facts. Squad 861 issued a citation to a driver where he said a plaintiff defendant me violated a law. I started another argument yesterday where I'm the plaintiff and the defendant, so we're clear. The citation lists pedestrian walking in left eastbound lanes violation, no ordinance, statute, or law given. District courts entered into the registrar a plea of not guilty on August 29, 2013 by defendant plaintiff. I was the defendant then. I'm gonna be the plaintiff when I do my cross complaint. And on 10/24/2013, outside the courtroom, Paul Berchi, knowing the plaintiff was under duress, demanding a not guilty plea, got plaintiff to agree to pay law library fees, $3, municipality fees, $20, criminal traffic surcharge, $75, making the demand due $98. I appealed that. I said I'm not paying it. I said it gave me a criminal record. And as me and Paul began to argue, a decision was entered and plaintiff was convicted of violating PMD 169.21.2A in paragraph A under, is it 169.212A? Rule of court, defendant claimed not guilty was under the law afforded due process of law where evidence could have been provided to substantiate the claims the officer made, presented before the court a video in which the officer's dash cam and body cam was asked for verbally and requested to be used in court to show defendant was not violating any law, right? That's what I said. I used paragraph G, court's rule of reasoning, suggested the parties made a clear agreement and the judge entered the agreement into the registrar without knowing the defendant was under duress, felt coerced, and demanded a not guilty plea be entered. The legal issue raised is, did the defendant deserve an attorney? Could the outcome have been different had an attorney represented the defendant and demanded her Fourth Amendment rights be adhered to? That was the page I sent to Judicial Official Cahill, correct? Then I sent him another page. State of Minnesota versus Sharon Lynette Martin. Motion to dismiss with prejudice all traffic violations resulting from original citation and any and all relief be applied. That's what I said under Rule 26. Under Rule 26, Sharon L. Martin requests under Rule 26 via email, text, mailing to P.O. Box 22278, Robbinsdale, Minnesota, upon acceptance of said request via email to Jeremy Maribel based on incomplete record in macro. A certified copy is requested due to missing cases or violations of traffic, disorderly conduct, trespassing cases. Sharon L. Martin claims to be missing. She litigated and won decisions under acting pro se. I won, right? In form of papyrus. A copy of her financial status will be sent, and I sent it. Argument. Motion to dismiss with prejudice, never to use any of these tickets to restrict, control, deny Sharon L. Martin. I gave you my date of birth. As plaintiff, defendant in this matter's driving privileges at the conclusion of said hearing, January 3rd or sooner, 2024. This is now what date? 27 VB 297284 as a result of 27 VB 137188, where petitioner requested at that time the charges be dismissed with prejudice and fines be removed and to be opened and reviewed for applicable law. I thought my rights were violated, didn't I, Paul Berchi? I said you didn't know that I thought the police presented you with an illegal video, and I gave you the benefit of the doubt at that time. Paul Berchi, Hennepin County prosecutor, prosecuting 27 VB 137188, showed the dash camera of the officer in question's behavior, which showed bias. The video implied plaintiff was targeted by said officer and charged with failure to yield to a pedestrian when the video showed 3 other cars present, where 3 cars had Caucasian drivers and she was the only black driver in the crowd. The video showed the 3 cars to be in the lane closest to the pedestrian, would have crossed The video showed the 3 cars to be in the lane closest to where the pedestrian would have crossed before crossing in front of the car she was driving. The other cars did not stop, would have hit the pedestrian before entering into the lane Sharon M. Martin was in. Due to the officer only stopping one of the 4 cars, Sharon felt targeted and discriminated against based on being stopped and a citation issued for only her. And then I put Doe X Ariel dot Doe VL Lord, what is it, Marion? And then I put SCH.district, comma 665F. I be putting this shit and I don't always know what I put. I need to write it down so when I have to reference it in court, I can read you under the law what I thought I was putting it under. Because I look it up and then I don't always write it down, take a footnote, or I'll take a footnote and forget to print it. Because then I need to know what it was. While discriminatory intent need not be only motive, a violation occurs when the evidence shows that the entity adopted a policy at issue because of, not merely in spite of, its adverse effects upon an identifiable group. I put PERS.ADMR of MAS, that's Massachusetts, versus Finney, right? I don't know why I put that, because I'm in Minnesota. Because Sharon Martin was the only black driver in the group, she felt targeted based on the officer's actions and the Robbinsdale Police Department's prior complaints of racial history. These are things I wrote, right? I mean, I took the time to write this shit. Events and hearings in the registrar. Should I read that to you? I don't want to read that to you. I don't want to read that to you. I want to talk about the relief sought because I should be going in here picking up a check. That's what I felt. I thought I should be given a check for like $8,000 is what I asked for, right? I want to get to the relief sought for that ticket based on all the stops I had thereafter. That's what I said. I wanted some relief. Punitive damages shall be allowed in civil actions only upon clear and convincing evidence that the acts of the defendant show deliberate disregard for the rights and safeties of others. The police, they showed convincing evidence that the acts of the defendant, which was the police officer, showed deliberate disregards for the safeties of others. That's what I said. Deliberately proceeds to act with indifference to a high probability of injury to the rights or safety of others. That meant that every time he stopped black people after that, he was going to get away with it. To me. And we ain't even going to talk about the video. Civil Code Section 3294 provides that a plaintiff can obtain punitive damages when it's proven by clear and convincing evidence that the defendant has been guilty of oppression, fraud, or malice. I said by that first ticket, they oppressed me because then they tried to take my driver's license. That was fraud. I said that was intent to harm me. It was straight malice. Hey, that's what I said. In this matter, Sharon asked the court to expunge the record, reinstate her driving privileges, and award damages based on denial of jobs, which supports her and allows for Sharon L. Martin to live above oppression, right? Because I was driving like to Bloomington. How many times did I get a ticket speeding, not stopping for people, disrupting traffic, going to work? Never. The last job Sharon Martin had, she made $14.85 an hour and was offered a job making $17 an hour. And based on the record, she was denied the job. Sharon worked at Kowalski's Market at least 60 days per her Department of Labor, and she asked the award to be based on the full employment, then at minimum 35 hours a week for 60 days out. The courts may award any amounts above per laws as applicable. And then I put at the bottom some shit, right? Why? Because I was offered this job at EDU, and they knew I was going to be on the bus, but they said they looked at my background history, this Zen education, right? This Zen education said they looked at my background history and I had all these tickets, so it made it look like to the school system I was a criminal, so I couldn't get that job, and that was $17 an hour, and I thought I just based it on, facts. I didn't even go into fallacy at that moment where I could have been targeted. Joshua where I said the police were now retaliating and trying to get back money that you got from that police officer. I said, after a while, you didn't sue the city and insurance. I said, you sued him directly. And because you sued him directly, you put me in harm's way, bitch.